Hello, everyone. Welcome to our webinar today, where we are discussing a very important bill that the Assisted Reproductive Technologies Bill. And we have today a very enlightened panel whom I will introduce in a short while. But before then, I want to invite the chair of LSK Nairobi branch to officially opening this session and welcome all of us on board. Um,
Thank you very much, Elvis. Um, Good afternoon to our distinguished panel of speakers, members, colleagues, and I also want to recognize the presence of Deputy Registrar, Madam Grace Sitati. Welcome to our webinar this afternoon. My name is Helen Namisi. I am the chair of LSK Nairobi branch. And on behalf of our branch, I want to say karibuni sana. Thank you for making the time this afternoon on a Friday. I know it's difficult on a Friday, but we felt that it was necessary to have this webinar so that we can actually interrogate the bill, the Assisted Reproductive Technology Bill 2022. As you may know, there is a call for comments on the bill, which is currently before Parliament. And this is one of the areas of practice that we have been discussing in our various webinars this year. We've had 2 webinars so far on this particular subject. We had a chance to even speak to some of the surrogate mothers, one who was at the last webinar that we had, as well as a donor, and to just get their experience, from a practical perspective. Being the client, what do they go through? What are some of the things that they would like for us as lawyers to consider when we are legislating on this particular area? And so it's important for us to interrogate this act. Also because having listened to the presentations in the past and listening to the people who have been in this area of practice, it would seem that there's a large gap that needs to be filled because we do not have any law that actually speaks to some of the issues that are real. For example, when you have a surrogate and they actually give birth, and then you have the name of the surrogate being inserted in the birth certificate, which means then the biological parents have to go and go through an adoption process for the child to become legally theirs. Some of these loopholes, some of these gaps, how can we legislate to ensure that the reality out there, which is that a lot of the families have to actually go through assisted reproductive technologies to be able to have children, that they may have a seamless journey. And so this afternoon, we're really, really honored to have 3 wonderful ladies who have been in this line of work, whether it is in Parliament, whether it is in actual practice like Enrica does, and Ayeta Lumbasio, who actually works at the IVF Center. So we have a very rich panel. I hope we will be able to embrace this opportunity. Let's look at this act, let's interrogate it. How can we make it better? How can we make it work for us from a practice perspective for our clients? How do we make it work for our clients, for our society? And with that, I want to say thank you, karibuni, and let's interact freely. Back to you, Elvis.
Thank you, Chair. Uh, without uh, getting more time, because we want the speakers to have adequate time, I'd like to just take this moment to introduce Honorable Millie Odhiambo, whom I believe is well known to all of us. Uh, I'll just give a very brief bio. Honorable Millie Odhiambo is a lawyer and advocate. She has a Bachelor of Laws from the University of Nairobi, a postgraduate diploma in professional legal studies from the Kenya School of Law. She also has studied democracy and governance in Les Asprin Center, Washington, D.C., and a postgraduate diploma in international course on human rights and humanitarian law from Raoul Wallenberg Institute in Sweden. She has also done a program on legal prevention and judicial control of corruption, and she has from Rome, Italy, and she has a Master's of Law in Public Service Law from the New York University in the USA. She is a legislator, a long-time legislator in matters to do with uh, these areas of practice, family law, and many other legislations which she has been very vocal in supporting. And she's also worked in the children rights space, and that and many other very stellar accomplishments she has. Please join me in welcoming Honorable Millie Odhiambo to give us her presentation.
Thank you and good afternoon. Let me apologize in case I fall asleep in the process. I've just gotten back from an over 20-hour journey, so I'm a bit tired, but I'll try my best. You have not given an indication as to time, but I will. How much time do you need me to spend?
Uh, uh, 30 minutes just to allow for an interaction.
Thank you. I'll
Yes.
probably, hopefully, take less. And the reason that I'm going to take less is because, as the sponsor of the bill, I am hoping to hear much more from people in terms of areas where they would want the bill to be improved. But I just want to start off by giving a background to this bill. When I joined Parliament, several women approached me who are having challenges. Some were having challenges in having children and had tried assisted reproduction technologies for long and were spending a lot of money. Some had gone through the process 3-4 times, some had gone to South Africa. And so a number of them, in fact, one of them met me at the airport and called me and spoke to me at the airport. And so they asked me, is it possible to provide a legal framework that could make this process, one, cheaper, but also just to protect the women and men who are going through this process from a lot of exploitation at that time. After that, I also met two women leaders, one who was then also a member of parliament and who was forced to adopt her own biological child because of the gaps that some people have made reference to. The other one eventually got a child through surrogacy and also indicated to me the challenges that she went through. So we actually have two members, women members of parliament that I know that have gone through this, and three male members of parliament who've gone through this that I know of. But maybe because of the issue of stigma and all that, only one male member of parliament is willing to speak openly about it. And even for the women, only one was able to speak openly about it. The others are not able to speak openly about it. And so what this bill seeks to do, and I'm sure as you all know this, as there's no legal framework dealing with issues of assisted reproduction technology. When I first started or brought the first bill, it was not even assisted reproductive, it was the IVF bill, but I benefited from the experience and knowledge of some of the medical doctors who are also in parliament, who told me IVF is only one form of assisted reproduction technology. And so the name changed eventually to Assisted Reproductive Technology Bill. The bill was first brought in the 11th Parliament. It was unanimously passed by the National Assembly. And when it went to Senate, Senate actually declined to pass it because Senate was hoping that they could come up with another bill. So they declined to pass this. Unfortunately, the Senate bill itself never saw the light of day. So again, I brought it in 2012. This time it was passed in the National Assembly, but with some amendments by members. I think one of the things I'll speak honestly too is that some people think that assisted reproduction technology will help the LGBTQI community to adopt children. That is not my intention. My focus is not on LGBTQ, neither is it not my focus. I'm not interested either way. My focus is helping couples that are having challenges, having children, to do so within a given legal framework. And then, so it passed in the National Assembly, but when it went to the Senate did not process the bill. And so it lapsed. So it has come in the 13th Parliament, but because it was already passed in the 12th Parliament, it has actually then benefited from a faster process. So it doesn't have to go through pre-publication scrutiny. There's usually a very long pre-publication scrutiny, but so it doesn't have to go through that. And that is why it has already come for first reading. So we are only waiting for the second reading. What does the bill deal with? If you look at the preamble, it tells you that it is an act of parliament to provide for the regulation of assisted reproductive technology, to prohibit certain practices in connection with assisted reproductive technology, to establish an assisted reproductive technology directorate, to make provision in relation to children born of assisted reproductive technology process, and for connected purposes. I will just highlight what some of the provisions in the given parts. The part one, which is preliminary, of course, gives a short title, and then the interpretation, application, and the object and purpose of the act. Then part two talks about the Assisted Reproductive Technology Directorate. Some people would have wanted us to have a bigger body, but the government was hesitant in creating more bodies that would cost taxpayers more money in the last parliament. So we agreed to settle with the Committee of Health on a directorate within the Ministry of Health. And so what part two then provides is for that it establishes that directorate, it gives the functions, the obligations of the national government and the county government, and composition of the directorate, and where there are needs for experts or consultants, because as you know, we are very limited experts and consultants. And that's why I'm very happy that we have Ruby today. Ruby is actually a lawyer that is working both from a medical, not both from, actually from a medical legal perspective. And we recently had a meeting with them, including with Enrica, who is also in the panel and who's handled a lot of these cases in court. And the bill really benefited from a lot of the feedback. Part three indicates what some of the prohibited activities or proposed prohibited activities, like it only regulates under what circumstances you can use an embryo, the posthumous use without consent of the person who is deceased, circumstances for undertaking assisted reproduction technology, use of embryo in a woman, and amongst other things. Then part four focuses on the rights of parents, donors, and children. And again, I think when the chair was making her introductory remarks, she alluded to some of the challenges that people face in court. So those are some of the things that we're talking about. Like we have situations where a surrogate mother, once she has a baby, then feels this child is so beautiful, I cannot hand over the child. Or in situations where then the parents are forced to then adopt their children. So what we are basically doing is saying, what are the rights that accrue and how can we make it shorter for parents, for children, and all the people that are involved. So part four is on the rights of parents, donors, and children. Then part five focuses on access to information. Part six focuses on basically licensing provisions. And then, of course, what is indicated in the bill right now as part 8, but should be actually part 7, is on miscellaneous provisions. And then, of course, the usual pattern on provisions on delegated powers. So in a nutshell, this is what the bill is about. If I can talk about it as an overview, I will let Enrica and Ruby talk at length about some of the issues that they've seen that were raised in our last workshop that are of concern in relation to the bill. And I'd indicated I will not talk much so that we get more time for people to give feedback on the bill. Thank you.
Thank you so much, Honorable Millie Odhiambo. Just for purposes of good order, we'll want to take comments, preferably via the chat. Anyone who has any comments or any questions, you can just type it on using the chat widget, so that our presenters we can then pick up those questions and comments and have a discussion after our presenters have finished. Before I invite my senior Enrica Dulo, I am informed that there is Dr. Kireki Omanwa, who has joined this call. Dr. Kireki is a leading family fertility specialist. So please karibu sana, Daktari, and we look forward to your remarks on this bill as well. But without further ado, I'd like to introduce my learned senior, Enrica Dulo. Ms. Dulo is an advocate of the High Court of Kenya with over 18 years post-qualification experience, stretching from civil society, academia, and private practice. She's recently been appointed a board director at Chemelil Sugar Company. She holds a Bachelor of Laws degree from Dr. B.A.M. University, India, and a Master of Laws degree in International Human Rights Law from the University of Essex, UK, postgraduate certificates in International Development Studies from the University of Oslo, Norway, International Cooperation and Development and Human Rights Concepts and Issues from the United Nations University in Tokyo, Japan. Ms. Dulo runs her law firm under the name E. Dulo and Associates Advocates. She's built her specialty in family law practice and has cut her niche in non-traditional family law practice area of gestational surrogacy. She's used her skills to develop a training package and has trained more than 100 advocates and 3 judicial officers on gestational surrogacy and the transfer of parental rights in Kenya. Ms. Dulo provides pro bono legal representation to juvenile offenders annually. So please join me in welcoming Ms. Enrica Dulo to make her remarks. Thank you, Karibu.
Hi, Elvis, thank you so much. Before I begin, I need to know how much time I have.
We were working with 30 minutes.
All right, okay. Fine, 30 minutes is fine. Let me see if I can share. I don't know if that's enabled. No, that's not enabled. So what I've done is my presentation is focusing only on part 4 of the draft bill. Okay. I've been made a copy, but I don't know how I can share. Millie, if you could kindly mute. So if you have the bill with you, my presentation is focusing only on part 4 of the bill, because you realize that as an advocate, I will only comment on that which I'm familiar with. Largely, this bill talks on the reproductive rights, which as an advocate, I'm not familiar with. My knowledge and experience largely is on the legal part. So I will start on clause 27.1. Clause 27.1 provides for who can be a surrogate mother, and it provides minimum age, and it further says that you must have given birth to at least one child and understand the rights and obligations it does not give a maximum age, which to me is very good. However, looking at the example of other countries that have legislated for surrogacy, example is UK, they allow even women who have made a decision to be childless by choice to also be surrogates. So probably that is something we can consider, we can think of. Someone who's decided I'll not going to have a child in my personal life, but I wouldn't mind having, I mean, being a mother for carrying a baby through surrogacy. Then also in the UK, I know that they are also not very strict on the maximum age. In Kenya, even though we don't have legislation, but I know when you go to the fertility clinics, they have an age limit. If some fertility clinics put the age limit at 35, I am aware of those others that once they pass through the medical test, they've been able to carry a child, whereas they are even beyond 40 years old. So probably that is something we can think of, because I know in the UK, they allow even a mother who stopped giving birth, maybe she's in her 50s, to carry a child for her daughter. So that is something we need to think of. If the person passes the medical test, then what is it? Why should the law stop them from carrying a child? Recently, I handled a case of surrogacy. The couple, they had triplets and they didn't have the triplets in Kenya. They went out, but when they came back now, they had to do the paperwork. So in looking at the profile of the surrogate, I was quite surprised. She was a 50-year-old woman and she managed to carry triplets. So probably that is something we need to think of. That's on clause 27.1. Then if you look at clause 27.8, nothing much except that where it talks of the surrogacy agreement, the first part, it should be surrogacy arrangements. You need to understand that the conversation between the parties, the independent parent and the gestational surrogate, the conversation between them, that you agree to carry a baby for me and all that, that is an arrangement. And when they agree and reduce in writing, then that is now an agreement. So clause 28.1, that should be parties to a marriage or commissioning parents intending to enter into a surrogacy arrangement with a woman, with any woman shall sign a surrogacy agreement. So we need to change that. Then if you go further to clause 28.2b, no, sorry, clause 28.3, it gives, it suggests the provisions that a surrogacy agreement should have. And I totally agree with what has been provided for in the draft bill. And I'm suggesting that we further add a next of kin for the gestational surrogate, and also the commissioning parent should appoint a guardian. The reason why you need a next of kin for the gestational surrogate, a lot of these women who come, who give themselves to be surrogates, like it to be hush-hush, which is okay for their privacy purposes. But should anything happen to them during the course of the pregnancy, or they've gone to give birth, then complications arise or life is lost, I mean, how will the hospital or the IP or the whoever was concerned with the pregnancy know who to contact? So it's very important that the agreement includes contact details of their next of kin beyond the name and mobile number, even ID, because our IDs are now biometric. It's very easy to use it to trace somebody. Then I'm sure Ruby will talk more on this, but there's need also in the agreement to capture a guardian appointed by the IPs. The reason is anything can happen during the term of pregnancy. Then you get the surrogate giving birth. Either it's a situation like what we had during COVID where there's lockdown, or it's a fatality that the IP, if she was single, she passes away, or whatever it is, but the gestational surrogate is not able to get in touch with them. She's given birth. All during pregnancy, she'd been prepared that she was going to give the child away. So what does she do with this child? So it's important that you appoint a guardian. And sometimes even in the case where the child is born and parties are no longer seeing eye to eye, there's a very good case law on this in Japan, where they went to India to have a child. The man had a genetic link to the child, but the lady did not have a genetic link to the child. So they go to India, did the process, went back to Japan. But in between, they separated and eventually divorced. So by the time this child was being born, I think it was called Dr. Yamuna or something, he had to go back to India to get his daughter, but he could not exit because he had a baby girl. The law in India does not recognize, as it is in Kenya, adopting a child of the opposite sex, even though this was his child. But India at that time also did not have adoption laws and all that. So it was, he went to India, stayed with his daughter for 1 month, but he could not exit. His mother had to come to India, stay with the child for 8 months. And there was no legislation. So it had to take a lot of process with the embassies even getting involved. And then you have to pull the tag, the best interest of the child principle, simply to get this child out. So imagine if they had separated and the man who had genetic link with the child refuses to come back for the child. And this lady here also says, you know what, I don't have a genetic link to the child, and we are no longer together, I'm not getting into the picture. What does the surrogate do? It's at this point that a guardian comes in to take this child temporarily under their care, as probably now a solution is sought legally on where this child should go. Then I move to clause 28.5. Clause 28.5 is very controversial. And as advocates, this is a clause that is denying us our bread and butter, because it says, and Millie, you are an advocate, so don't deny us our bread and butter. This clause says that the entry in the form shall be conclusive proof of parentage of the child and shall be used for purposes of registration of birth and other legal purposes. Now, I've done comparative analysis of UK, Israel, Australia, state level, India, and South Africa. And even if you look at the individual states in the US that have legislated on surrogacy, there has to be a legal process for transfer of parental rights. They don't just allow that the agreement that parties have made is what should be used to transfer the parentage. So on that, we need to look also at what are the international best practices. And if we do not do that, then we will, there will also be an advisory by Western countries that you cannot, if you are a national, let's say of the UK, you cannot have a child through surrogacy in Kenya because the laws that we have do not conform to the practice in the UK. Secondly, Kenya is known, if you look at the US human trafficking report, they release it every year. Kenya is on tier 2 watch list for human trafficking. We are known as a source, transit, and destination country for human trafficking. Human trafficking includes children. Where a surrogate has gone to hospital to give birth, it's not the responsibility of that hospital to investigate and find out the validity of the surrogacy agreement presented to them. Therefore, it's important that we have a legal process, because when they go through the court process, remember the court will also have, there will be a checklist to confirm that this child belongs to this party, such as probably DNA. So on the issue of protecting children and considering that Kenya is known as a source, transit, and destination country for human trafficking, I think there should be a legal process for the transfer of the transfer of this child from the surrogate to the intended parents. Then it's also important that we have DNA testing after birth to prove genetic link. Being a third world country, we have a lot of vulnerable women. We have a lot of women who call, says, you know what, I'm pregnant. Whether the pregnancy was planned or not, but I cannot take care of. I'm just waiting to give birth mtu achukue mtoto, which is okay. Under the law, you are allowed to give consent to give away your child. Sometimes they abandon the child. However, if someone had bad intention, because we know that organ harvesting does happen, someone who has bad intention will lie to this lady that I can take this child under my care, give her to me, we will simply do an agreement between us and present it when you are giving birth that this is a child you've given birth to through surrogacy. You see, this person doesn't have a good motive. But if you insists that it has to go through a legal process, then you will not find people. I mean, adoption or hiring a lawyer to help you in the legal process in the court where you've had a child through surrogacy is very expensive. I don't think someone who is involved in the illegal trade of trafficking would be interested in spending minimum $500,000 to go through the legal process. So for purposes of protecting children, for purposes of also not making Kenya be flagged and advisory issues issued against us, we need to have a legal process, because otherwise the next thing we'll know is that we will be having we'll be dealing with a lot of cases of involving human trafficking, involving organ harvesting, illegal organ harvesting, and Shakahola is alive with us. It's ongoing. 2 days ago, we had the report that was released by the government pathologist, Dr. Johansen Oduor, that the bodies that so far had gone through autopsy, most of them had their organs missing. So we need to be alive to that. Then we move to clause 30, subsection 3A. This ties to the previous clause that I've just finished on. It says the commissioning parent or parent shall be listed as the parent in the birth notification and birth certificate. Now, Section 10 of the Births and Deaths Registration Act provides that the birth mother is the mother. And as previously mentioned, all countries that have legislated on surrogacy, what they have is that the surrogate is the birth mother. Then there is a legal process. So if the surrogate is recognized as the birth mother, then the notification should be in the name of the surrogate. Then where there's a legal process, if a birth certificate had already been issued in the name of the surrogate, after the legal process, you just change that birth certificate and you have now the name of the commissioning parents. Now, the bill proposes for an ART register, which is very good. However, the gap that I see is that the bill has not proposed for a surrogate birth register. The reason why I think it's important to have a surrogate birth register, if you've handled adoption petition, remember once you get the adoption order, you serve that order to the registrar at state law office, and you are issued with an adoption certificate. And it's only one office in Kenya that issues that, the state law office in Nairobi. Then the state law office in Nairobi, once they issue you with an adoption certificate, you go to, if the child that was adopted already had an existing birth certificate, you go to the civil registry where that birth certificate was issued, and you present them with that so that they mark in the system that there's an adoption order on this, because Kenya allows children who've been adopted to be reissued with the birth certificate that cancels the one of the biological parents and now lists the adoptive parents as their parents. So for purposes of accountability, for purposes of tracking, for purposes of transparency, we need to track and show that birth notification serial number, this birth certificate serial number, this was issued out of birth notification, this. But how come the birth notification has a different mother listed and birth certificate has a different mother listed? So the missing link will be the surrogate birth register, because it will show that this came about because this child was, the parental transfer happened through surrogacy. Secondly, for purposes of knowing, of having records of knowing numbers, how many children are we having through, how many births are we having through surrogacy? Because for purposes of informing legislation, it's good when you argue on numbers. There's a directorate that is being created under this legislation for purposes of arguing why you need funds allocation, why you need more funds allocation. I mean, you argue based on numbers. So when you have those numbers, it's very easy to tell, because for adoption, it's very easy. The records are there. You go to the family division, they have the records. Family division Nairobi, they have the records. Each high court that conducts adoption, they have their own register and they have records. So why not do the same also for surrogacy? And it will be easier to have this in place if we have a specific register that records once you come from court with the order and you take it to whichever authority that will be there, whether it's the civil registration authority or still the state law office as for adoption, but they have a specific register for recording surrogates births before you transition now to a birth certificate that is listing the intended parents. Now, if you go further to clause 30, subsection 4C.
Sorry to interrupt.
Yes, Millie.
Yeah, I can see, I think it's Dr. Kireke who is requesting to say something before. Is it a she or he runs to theater?
It's a he. It's a he. Mheshimiwa, it's a he.
Yes, I've just seen in the chat that is requesting to say something. I think it would be beneficial for me, especially if I can get a feedback from that expertise. Thank you.
Thank you so much, Chair. Thank you, Mheshimiwa. Thank you, learned colleagues. I don't know whether I also qualify for that. And thank you very much for bringing this session together. And thank you very much, Mheshimiwa, because you have spearheaded this process for the last few years. And we are happy as the medical fraternity that something is coming up, because this is an area which is sort of a vacuum in this country. And because of that, we who are practicing in this area, we see quite a number of things which we are not happy about. And basically, we are actually not able to do a lot. So our thanks as a society, that is the Kenya Obstetrical and Gynecological Society, of which I'm the president, and also as a practicing fertility specialist. I have gone through the bill and I will go through it once again, and I'm listening and I'm hearing very, very good things coming from Enrica. But there are a few things right from the beginning of the bill. For example, we're placing in a woman eggs and sperm. That is technically not possible to collect eggs and insert them in the same woman with sperm at the same time. But I think these are small areas which we will, as a society, put our memorandum together and send it to you. The issues that have been raised by Enrica, it's very good you're talking about a register, ART register. It can be a good thing, but it can cut both ways. Because first of all, let's remember that this is a situation which is very stigmatizing in our society, whereby a woman or a couple, for that matter, cannot have a child. And when we talk about now saying that we are going to put you in a register somewhere so that we can know who has this disease, who has this problem, it may even stigmatize them even more. So this is an area which I think we need to debate a little bit more on it, because it is a medical problem, just like hypertension, just like diabetes and so on. And if we don't have a register for couples who have diabetes and hypertension, so the question would be, why do we want to have a register for these couples who have this problem? A very, very good thing that we are talking about is about surrogacy, because some of these couples may not be able to have babies on their own, and they need somebody else to do that. And I think personally, I don't know whether it will be possible. If there'll be a challenge, then maybe you could delink the surrogacy from the bigger ART bill, but I think we can discuss about it and see if that is going to be a challenge, then maybe deal with this, because the issue of the civil registry is a very thorny issue. And it's a big hurdle for most couples who are undergoing this process. These are my few thoughts for the moment. We will go through again, and then we will send our memorandum. Thank you very much. And I will try and listen as I'm operating and gather more information. Thank you.
Thank you, Doc. Okay, now we proceed. I was almost coming to an end of the comments I had on the bill. If you look at clause 30, clause 34C, it's introducing insurance. And I think this is very, very good, because I remember once a surrogate asked me, Enrica, what is in this for me? because I'm seeing there are, when you look at the agreement that we did then, there are all these requirements that I need to do, all of this protection for the IPs, but what is in it for me? So it's important that there's insurance cover, and the bill has made mention of that. Reason being, remember, when a woman is pregnant, whether you're pregnant through surrogacy or your own child, the body does not recognize that this is not your pregnancy. If the pregnancy is to put your life at danger during the pregnancy or at birth, you will suffer the same. So in the unfortunate event that the surrogate loses a life, and considering also that we are so far insisting that a surrogate must have had a child, and a live one at that, the insurance policy, the benefit that will come from the life insurance policy will, to some extent, cushion the beneficiaries economically. So it's very important, and I think it's key that we have that. Then I move to my last comment on the bill. We have a clause 31, where it says a person shall not do any act at any stage to determine the sex of the child to be born through the process of ART. Now, I want to be the devil's advocate on this. I mean, this is not a natural conception process. And probably I want to have a child through surrogacy, but if I'm a single woman, I would want to have a female child. Why am I being restricted that I'm leaving it to nature? So I think anyone who goes through ART should be given the freedom to decide the gender of the child that they want to have. So that marks the end of my presentation on the bill. Millie, I'm going to share that with Juliet of the Cradle so that she can have it, because I made comments on the bill itself. Acrobat Reader allows that. Now, allow me for a further 10 minutes to quickly do a comparative analysis of 5 countries, UK, Israel, Australia, India, and South Africa, a comparative analysis on their ART law and gestational surrogacy practices. On legislation, UK has separate legislation for ART and a separate legislation for surrogacy. The one for surrogacy was passed first in 1985, though it's been revised later. The one on ART was initially passed in 1990, then revised in 2008. Israel also has separate legislations. They have the public health IVF regulations, and then they have the Israel Embryo Carrying Agreements Act to deal with the surrogacy, passed in 1996. Australia, they have laws regulating IVF and surrogacy state to state. And then India also has a different regulation on surrogacy and a different regulation on ART. India passed theirs around December 2021. One of them came into force, I think they were either 19th and 20th December. Then South Africa as well. They have the National Health Act that covers IVF, then the Children Act, Chapter 19 of the Children Act that covers surrogacy. So you see in all these countries, they've separated the clinical and the legal. And probably this is also now the conversation we need to start having in Kenya and as advocates, because if you marry the two, and we have to ask ourselves, why has this bill dragged in Parliament for all this time? It's not been passed. Is it the proposals in the legal part or proposals in the medical part that is making it drag? And if it's proposals in the medical part, then why don't we hive off what concerns us? The doctors deals with what concerns them, we deal with what concerns us. And there is no harm even if they are not passed simultaneously, as the legislations that I've shared, except for India, they did not come into effect immediately. And as it is, though we don't have anything specific legislation on ART, it's happening because the Constitution provides for the right to health, including reproductive health. So as lawyers, as members of LSK, this is something a conversation we need to start having. Should we have separate legislations? One looking at the clinical aspects, ART, and another one for the surrogacy arrangements. Then genetic link. In all of these countries, there has to be a genetic link. If you are single, then you should have a genetic link with the child. If you are a couple, then at least one of you must have a genetic link with the child. But you cannot decide that I'm not going to carry this child and I'm going to use a donor, because then why don't you adopt? And we will not be, we are not short of children who need to be adopted. Then again, in all these countries, they allow, in 3 of these countries, they allow for only altruistic form of surrogacy. Altruistic means that there is no official compensation, there is no monetary gain. But Israel allows for commercialization. India is dual. India allows for both artificial and altruistic depending on the intended parents and their residents. In our act, we don't allow for commercial, but there is compensation. We all know that the surrogates go into it because of the money, but the reason why you cannot you cannot just make it commercial because then it will cause a red flag, especially to Western countries, that Kenya has commercialized surrogacy, so we will not allow our citizens to go. Because if you commercialize surrogacy, you will not have citizens, people coming from Canada, people coming from US, people coming from Australia or UK coming to Kenya, because then we shall have been blacklisted as not being a destination for couples to consider for surrogacy, even if our costs are lower. Then on same-sex couple or single or live-in, the draft, unless I'm mistaken, I've not seen a provision where the draft is allowing for a single woman to have a child through surrogacy. And then this is also my question. The Children Act allows for a single lady to adopt. So if the Children Act already is allowing it, why is a single lady not allowed to have a child through surrogacy? This is something we need to think about. In UK, very interestingly, until 3rd January 2029, the Human Embryo Fertilization Act did not allow for a single woman to have a child, but they allowed for gay. But they had an amendment, and now single parent can apply to be an intended parent, so long as you use your eggs. Now, in Israel, they lifted. There was a Supreme Court judgment in 2020, and finally, the restrictions were lifted on 11th January 2022 on same-sex couples, and also a single woman can. In Australia, it depends on the state. So if you are residing in Queensland, Tasmania, or New South Wales, then gay couples have a right. And again, if you are single, then also you need to look at, there are only a few states that allow it. In India, they've prohibited if you're single, they've prohibited if you are gay. In South Africa, they've allowed it. You can have a child if you're single or if you're gay. And South Africa, it's also because, I mean, they have legislation that recognizes LGBT. So you cannot recognize LGBT, but then you don't recognize their right to reproductive health. Then I'll look at surrogacy agreements. In all these countries, surrogacy agreements, except for Israel, surrogacy agreements are not enforceable if there's a dispute. So in the UK, yes, you can enter into an agreement, but should there be a dispute, it's not enforceable. You will have to go to court. I was looking at case law in the UK. Some judges have sided with the surrogate, others have sided with the IPs, others have said the child stays with the IP and the surrogate will have access, despite the fact that the surrogate has no genetic link to the child, because this is an issue of gestational surrogacy. Now, in Israel, the agreements are enforceable because in Israel, before you go through surrogate, you go through IVF, your application and all that has to be approved by a state-appointed committee. In Australia, if there's a dispute, it's not enforceable. In India, not enforceable. In South Africa, it depends on whether the agreement was validated or not. In South Africa, you have to go, once you've entered into an arrangement with a would-be surrogate, but before the transfer happens, you have to go to court to have your agreement validated before the transfer happens. And if you do that and there's a dispute later, you can enforce that agreement. But if you do the other way around, where the transfer is done, you confirm pregnancy first is when you are taking the agreement for validation. Should there be a dispute, then you cannot seek for protection under the law. Then profile of the surrogate, UK minimum age is 21. And interestingly, which I had mentioned, there's no maximum age limit for surrogate in the UK, so long as the doctor certifies you that your uterus can carry a child. Then in the UK also, child-free women by choice can apply to be surrogates, which is very, very interesting. And if you ask me, it's very progressive. In Israel, the surrogate cannot be a direct relative of the intended parents. In Australia, surprisingly, they've lowered the age. So long as you are an adult, meaning from 18, you are accepted. But also it depends on state to state. Some states insist on 25 onwards. In India, between 18 to 35. So India has put an age limit. You have to be lower than 35. Again, they insist you must have at least one own child. Then in South Africa, the surrogate mother must have at least had one pregnancy and one viable delivery. And once again, I'm sharing this because when we look at when we do this comparative analysis and look at practices in other countries, it helps inform us what kind of provisions we'd want, what kind of legislation we'd want in Kenya. Then maternity leave rights. In all these countries, maternity leave rights are granted to the surrogates. And Australia, very interestingly, if I have a child through surrogacy, and probably I want someone else to come and help me look after the child once the child is born, and I'm not interested in applying for maternity leave, but let's say my sister or a friend or my mother who is still working has agreed to come and help me look after the child, they are allowed by law to apply for maternity leave rights. In India, they don't have legislation on it, but there's case law. In South Africa, there's also case law where this gay couple had a child. So the man, the person who considered himself as the female in the relationship, once the child came, they went to their employer seeking for parental leave, and they were denied. So they filed a petition at the Employment and Labor Relations Court, and the judge agreed with them that, look, South Africa has legislated and recognizes the rights of LGBTQ. So if it recognizes their rights, and also we've allowed them to have children through gestational surrogacy, it cannot then be that we don't recognize their right to bond with that child. And more so when you put in the best interest of the child, it's in the child's best interest that they bond with their parent, not just in the first days or first months of their lives, but it gives it gives an opportunity for that to be developed. I'm almost done. Then we move to legal motherhood, which in all these countries, the law recognizes that the woman who brings forth is the mother. UK, Israel, all the different states in Australia, India, and South Africa, the woman who brings forth is the mother. There is a legal process for transferring. It's not automatic that you give birth and the transfer happens at the hospital. The next one is gaining of custody, and this is now where we have a huge problem in Kenya here. In UK, if the surrogate was married, the law recognizes the surrogate and her partner to be the legal parents of the child, and they must provide consent. When they provide consent, the UK is very interesting. You provide consent, and the intended parents can only approach family court, which is the magistrate's court, between when the child is minimum 6 weeks and 6 months. If they pass that window period, if you go to court, for whatever reason you delay till the child is past 6 months, then now you have to go to high court for adoption. If you look at one of the case law in Kenya where the couple had a child, had twins, and on recommendation of the AG, they straight away got birth certificate, and a year later, and birth certificate and passports, and a year later when they went to the US embassy, because the IPs had come from Kenya and presented the documentation, the UK embassy, said no, you got these children through surrogacy, and you cannot straight away present birth certificate that they're yours. Whatever you do must conform. So they go to high court, to constitutional court, for the court to make a declaration is when now they went to the family division to adopt. If you read that decision, it's because there was no dispute between parties. The problem is the children were past 6 months. So as per the law in UK, when you have a child through surrogacy, past 6 months, if you had not made transfer of parental rights, you have to go through adoption. Here, the children are past 6 months, but they've had birth certificate, they've had passport. So they had to go to constitutional court for an interpretation. Then those orders were given to them. They went to the family division. The AG uses this case a lot, but if you read it and you understand what happens in the UK, you'll realize that there was no dispute between parties. It was simply not following procedure as it is in the UK, because that is where parties lived. In Israel, as soon as the child is born, within 7 days of birth, you apply for paternity order. And remember that the surrogacy agreement had been pre-approved by a committee. In Australia, they lower it between 28 days to 6 months. You go to the lower court and apply for parental order, the intended parents. After that, like in the UK, after 6 months old, then you have to go to the High Court for an adoption. But if you look at all these, if you look at all these processes, adoption comes only as an alternative. It's not the first process that these countries suggest. In India, you go to the magistrate's court as well, a magistrate of first class or above. Again, magistrate's court. In South Africa, because you had your agreement validated in court before the embryo transfer was done. So once the child comes, you just go back to court and you present your agreement that had been validated. Probably a file was opened, there's a register, it was registered, stamped. So once the child is born, you go with the birth, I presume, I'm not sure, you go with the birth notification. The judge confirms that and they give orders that a birth certificate has to be issued. But when you look across all these 5 countries, gaining of custody by the IPs, it has to be a legal process. Now, the last one will be the rights of the child. Again, in all of these countries, the rights of a child born through surrogacy is equal to a child born naturally under the law. I know people have asked that can an adopted child have equal rights to children born naturally? Adopted children have equal rights. So do children born under surrogacy. The Children Act and the Constitution of Kenya is very clear on that. And even these countries, what they provide is that these children, whether you've gotten them through surrogacy, they have equal rights. They have a right to enjoy equal protection under the law as children born naturally. So with that, ladies and gentlemen, that marks the end of my presentation. Thank you. If you're in the profession and you are asking the remuneration order, you will just have to inbox me for my remuneration order on surrogacy matters, and I'll share. Thank you. Elvis, back to you.
All right. Thank you very much, Senior, for that very comprehensive, I would say, presentation. It is, we're running really out of time, so I would want to just invite Ruby to just talk to us from her perspective as a professional. Miss Ayeta Lumbasio she holds many hats. She's a lawyer. She has an LLB. And she also has an MSc, Master of Science in Medicine, and is a PhD candidate right now. So she's an advocate, a bioethicist, a scholar, member of the LSK, the European Society of Human Reprofunction and Embryology, very big words, American Society for Reproductive Medicine. She's also an associate member of the Kenya Medical Association and the Bioethics Society of Kenya. She's currently the legal and ethics officer for the Nairobi IVF Center, Law Center. Her areas of interest are in assisted reproductive technology, stem cell, genomic sequencing, organ donation, bioethics, and medical law. Please join me in welcoming Ms. Ayeta Lumbasio to give us her brief remarks on this as we take more comments and go towards a conclusion of this presentation.
Sorry, everyone. I was a little bit electronically challenged. You'd think in this era I would have learned how to be suave and stuff like that, but that I leave for the youngsters. Youngsters, munisaidie tafadhali. So Ayeta Lumbasi, as you've heard, is my name. Sometimes I go by Ruby. And I'll just dive in quickly because Enrica has spoken a lot about surrogacy that I will not speak a lot on. So if you have your bill, I have mine here. So I'm using this as well as my comments since we cannot be able to share my presentation. So just from the first word, just from the definitions, Ukombele, assisted reproductive technology, the use of the word laboratory dish is a little bit restrictive. That should be either done away with or perhaps amended so that we just don't fertilize these embryos in a laboratory dish or a test tube or something like that. The most important element is that it is done outside the body. Most of assisted reproductive technology is done outside. The video is paused due to problems. Okay, outside the body. Secondly, assisted reproductive technology expert, meaning an obstetrician or gynecologist that has specialized in reproductive endocrinology and fertility medicine. Dr. Kireki would have heard here say, it's not just gynecologists alone who are, gynecologists ni madaktari wa wamama. Kuna madaktari wa wababa pia. And fertility is not just a woman issue, it is a man and women issue. So that is a little bit restrictive when you just insist that they have to be gynecologists and embryologists. So that should be amended as well. The meaning of child down there, I think we should adopt what we have in the Children's Act. That here it's a little bit restrictive. Let's just adopt what we have in the Children's Act and go ahead with it. And then on the next page, couple means a male and a female who are in association, notwithstanding whether such association may be recognized as a marriage under any law in Kenya. That is fine, but because of course, a couple, male and female. But I'm just wondering about the intersex. Isn't it discriminatory about the intersex? I will not talk about the gays because we still don't have a law on same-sex selection, on same-sex marriages. But we are progressive and we have issues on the intersex. And as you will realize, some of these intersex persons may be people who even have both organs. So when you restrict it to just a male and a female, we are being a little bit restrictive. Someone told me court, maybe perhaps you should add court, High Court of Kenya and all other related, but I think that covers, court covers. And then cryopreservation. Cryopreservation in basic terms is freezing, as in it's just a fancy word for freezing. So if we are going to define cryopreservation and not put that word there initially, process of cooling and storing, what is cooling and storing? So we need to redefine that. And then it is the freezing of biological materials. So it means the assisted reproductive technology process of cooling and storing, maybe perhaps freezing, so that the freezing isikuje tu kwa mwisho peke yake. It is something that has to be appear mapema. And then embryo down there, embryo, we're still on definitions. I'm just going through the act. Embryo down there means a live preborn person. This becomes a little bit complicated, especially when you look at our constitution, which says that life begins at conception. So what do we mean by a preborn person? Are we acknowledging that this is already a person? Does it have all the rights and responsibilities of a human being? Do we want to go with that, a live preborn person, or do we want just to assure that embryo, we will wait until this live preborn person has been implanted in a uterus for us to start giving it rights and responsibilities? Because as it is right now, which I am pro actually, because I am pro giving embryos, the status of embryo, I am pro giving statuses to embryos. But as it is, it will bring in a lot of confusion because now it goes back to the constitution where now we are saying conception starts at, life starts at conception. So it becomes, we should maybe perhaps change that. And unless we want now to go with embryo being a person already. What else yeah, primitive streak. Primitive streak means an embryo that develops in the early stages of human reproduction that is to be taken to have appeared in any embryo not later than the end of the period of 15 days, beginning with the day when the gametes are mixed, not counting any time during which the embryo is stored and the presence of which signifies the creation of a unique human being. Primitive streak does not just appear in embryos. Primitive streaks can appear in an egg, can appear in a sperm. So by just saying embryo can appear, embryo is the last stage, the zygote. There are many stages before a preborn person, as we are claiming, becomes an embryo. So there are many stages that it goes through. So just assuming that the primitive streak will only appear the embryo is a little bit minimizing. Inafanya tunakaa haiko vizuri sana. So let's proceed. Section 3, is it section 3? Yes. This act applies to all processes of facilitated human fertilization undertaken outside the human body, whether or not the process is completed outside the human body. This brings me back to my definition that I was talking about, assisted reproductive technology, where it just says laboratory dish, blah, blah, blah. I think this would be a better, if it's modified, it would be a better definition of assisted reproductive technology, because most of this assisted reproductive technology actually happens outside the human body. For example, in vitro fertilization, the cornerstone of assisted reproductive technology is actually basically Latin for outside the body. So instead of just saying laboratory dish, blah, 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 perhaps we should emphasize on the issue of outside the human body. So part 2, the Assisted Reproductive Technology Directorate. That I do not have a lot to comment on. I am just glad that they're doing, especially D, developing programs for awareness creation on the methods of assisted reproductive technology treatment. You will agree with me that a lot of people do not know the kinds of assisted reproductive technology treatment that are ongoing in Kenya at the moment. Because, in fact, before I even go there, perhaps Millie, Honorable Millie, I got used to calling her Millie when she was at Credo. Honorable Millie had said that this bill started out as an IVF bill.
It's okay, you can call me Millie.
Oh, okay. Then it came to assisted reproductive technology. And if Dr. Kireki was still around, if he's even listening to me right now, he will tell you that right now we are actually moving away from assisted reproductive technology. We are on the medically assisted reproduction. Why we are on medically assisted reproduction is because when you talk about assisted reproductive technology, you're limiting to those things or procedures that are actively involved with machines and stuff like that. We are not considering things like IUI. IUI, for those who did agriculture, is basically insemination. Ile ya kuweka ng'ombe sperm kwa ng'ombe nini. We have that in the human beings, but it's called intrauterine insemination, where IUI, where you get sperm and put it in a woman's body when she's ovulating and then it fertilizes. But when you say assisted reproductive technology, by the virtue of the word technology, you're already eliminating that. And as you can see, even in the bill, we have not even defined IUI because it's assisted reproductive technology. So it has limited some of the provisions, some of the treatments that are available to people but cannot be accessed through. So I am excited about develop programs for awareness creation on the methods of assisted reproductive technology treatment. That is good. I am excited on M, disseminate information to the public on reproductive health that may relate or affect assisted reproductive technology. And of course, establishing and maintaining a confidential national database on persons receiving assisted technology. This I am with Dr. Kireki. We are Africans and Africa is our business. Fortunately, I don't like the person who says that, but whatever he says is true. We do not want, as Dr. Kireki said, assisted reproductive technology is something that a lot of people are not so public about. It is stigmatizing. As much as we are already in 2023, it is something that is a very stigmatizing, as in, I will tell you for a fact, I have worked with at least 5 fertility centers here in Kenya, which I still work with. And I will tell you for a fact that there are some people who even come very early in the morning, 5 in the morning, with buibui, wamejifunika kila mahali, so that even the watchmen do not realize that they are coming to do assisted reproductive technology. So what happens when you get into such provisions, and then these are people that you want also to put them in a public database, even though it is a confidential database. We know what confidential means. It is not that confidential as such. So what happens, as Dr. Kireki said, it is double stigmatizing, because you are going to recognize this person as, it's just saying like all cancer patients there should be a database for all cancer patients. Like it's a disease, like every other disease. So I am not so keen on unless we really change our confidentiality laws and our information laws and stuff like that. But the idea of a database is something that I am not so keen on. Providing, now we are on 7C, provide regulations to ensure assisted reproductive health services are covered by every health insurance provider, including the National Health Insurance Fund. I will tell you for a fact, ART is extremely expensive. The most cheapest, other than IUI. IUI, you can do it for 50,000 to 90,000, the insemination one. But anything that is ART related will go upwards of 400, 500,000. And most insurance do not cover it because they consider it as non-essential. They actually classify it as tertiary. It's not primary care, neither is it secondary care, it's tertiary care. So they do not classify it. So what am I talking about here? Instead of just ensuring that it is NHIF alone, perhaps other insurance providers, the government should compel other insurance providers, the same way they give other insurance covers for other diseases, that they should also give coverage for this, because it is quite expensive and a lot of people go through issues. So prohibited activities, that is part 3. I'm going as fast as I can because my senior Enrica decided to take some of my time. Enrica utatuma coffee. So prohibited activities, 12.1. No person shall make use of any human blah, 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 reproductive material for the purpose of creating an embryo unless the donor of the material has given written consent in accordance with the prescribed regulations to its use for that purpose. It is fine, yes, but I just want us to consider the idea of embryo donation. I can see in the chat, there's a lady, or is it a gentleman, who has said there are issues where people have to get both gametes, as in someone does not have a viable sperm, another person does not have a viable egg, so they will need both. And then instead of creating both from scratch, then they just get donated. One that has already been created and is there, it's in storage, so they get one there. So if it is anonymously donated, it will become a little bit hard for the other party to write a written consent. Though I'm not saying that it should be changed, I'm just saying that it should. We should put that in mind when we're talking about that. So on 15, a person shall not undertake assisted reproductive technology for C. I'm talking about C. Purely speculative and commercial purposes. What is speculative? We have egg freezing. It is something that is happening. Women are freezing their eggs from an early age because maybe they've not gotten a sperm donor or a husband. Maybe they want to proceed with their education or whatever. So if we are going to say to limit that a person shall not undertake assisted reproductive technology for speculative purposes, then it becomes a little bit hard, because are we now limiting people from, saying that they do not want to give birth now, they would want to give birth perhaps when they are more financially viable in their 40s or, late 30s. So this is not something I have issues with that we should let, because egg freezing and sperm freezing is speculative. So purely speculative purposes. So that is something that we should also reconsider. Also, it may be speculative in such instances where you think you have cancer or a certain disease and you want to go for treatment. You have not been diagnosed yet, but you think you may have it and you want, because perhaps your people had it and you have not diagnosed yet, and then you want to freeze your eggs first or sperm so that you can go for treatment and diagnosis, because some diagnostic technologies are so thorough, they will mess up with some of your issues. So I personally think that restricting people not to do ART for speculative purposes is telling people you cannot freeze your eggs, you cannot freeze your sperm. And I think it's a little bit not only discriminative, but totally uncalled for. That's just my opinion. And then 19E, as Dr. Kireki had mentioned, the issue of just placing sperms on eggs or embryo in a woman, that does not happen. You can't place eggs in a woman. So I'm not sure where that came from, where a person shall not place sperms and eggs or embryo in a woman except in persons of a license, wherever. So there's nothing like placing eggs. You can place an embryo, you can place sperms, but you just don't place in a woman. You actually transfer them in a uterus. So the terminology used there is a little bit not medically recognized. So that should change. And then part 4, rights of parents, donors, and children. 20, where the sperm of a man or an embryo, on any embryo, the creation of which was brought about with the sperm of the man was used after the death. This is about posthumous assisted reproductive technology once someone has already died, because there are people who are already in the treatment process and then a partner dies, or they've already accepted that they have issues, they have infertility issues, and they're going to undergo treatment. So they make plans to do treatment, and perhaps before the treatment commences or when it is ongoing, one party dies. So here, I believe one of the things that needs to be added here, that it should be, even though the person gives consented, it has to be informed consent in writing. In my opinion, when the regulations are done to monitor some of these things, it should even go as far as saying perhaps this informed consent in writing should have been registered at the children's court, perhaps, or any court, like the way they do parental rights agreement and stuff like that, so that women, we are known to take advantage of such situations, so that we do not take advantage of using a person's sperm after his death, just perhaps to inherit or have access to wealth or something like that. So I would like the words informed consent in writing to be added, and in the regulations that will come up to monitor such, the informed consent in writing should actually perhaps be registered in a court, so that it is a form of an order, so that this person, even if you use their particulars after their death, it is in the right manner. And then 21(3), every person has the right to access the highest standard, blah, 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 blah. An assisted reproductive expert shall, before providing assisted reproductive technology service, provide this following in A. I just want it written, the issue of informed consent to be there. Why am I insisting on the informed consent? Because women sometimes are actually forced to go through assisted reproductive technology, not because they necessarily want to, but because they've been threatened. Usipozaa nitatafuta bibi mwingine. Usipofanya hivi, I will do ABCD. So this informed consent should be one that has been given full disclosure. The party is competent. They have the capacity to do that. They are doing it voluntarily. You'll be shocked at how many women do not even want to have kids, leave alone just to go wherever. They should also do it voluntarily, and it should be given to them or given out in a language that they understand. So perhaps in the informed, of making an informed decision, this should be taken into account. I see we have their informed decision, but also it should be taken into account. And also another thing, that before they make that decision, there should be a counseling process provided. So maybe we should just add counseling there. And then on 22, national and county governments shall put in place measures to ensure that all intersex persons have access to assisted reproductive technology services. This goes back to my part of couple definition. So if we are bringing in the intersex people, some of them who have 2 organs or stuff like that, then perhaps we need to reconsider how do we want to have the word couple in the definition? Do we want to eliminate it, or do we want to expand it to include all parties that are going to undergo assisted reproductive technology? I am happy that there's death. They have provided for issues, what should happen to any to any gametes that are served when somebody has passed away, death and incapacity. In 23 part 2, the consent referred to in subsection 1 shall make express provisions on what should be done with the gametes in case of the death of any parties, acknowledging. The problem that I had initially, and which I still do, is how long should we store these gametes? As I explained in a more previous meeting, is you can keep embryos for as long as possible, as long as you have space. As in, they can even go on for 100 years. But do we want to start using embryos that were created 100 years ago to bring life forth? And then who is this? Whose child is this? Is it a child? Is it a grandchild? Is it, So as much as the Tukiendelea, you'll see it has said 10 years, but we've not been given processes of disposition. So even if 23.3, I would like it just to specifically include that 10 years, how long for cryopreservation? As I said, cryopreservation is just a fancy word for freezing. So how long should we freeze? But we've only been given an opportunity to freeze these embryos, which is already a sperm and an egg that has been fertilized, but we've not been given a timeline for gametes, which is sperm or egg. As I said, you can freeze them for as long as you want, but the limits on how long should be frozen should be given there. So I'm happy we also have 26.3, where we are talking about separation and divorce, where a married couple obtains divorce after the creation of an embryo. You realize that with our definition in this act, the embryo is already a preborn person. So we are already saying that this preborn person, who apparently has rights, because if it's already a preborn person, it's already a child who already has rights like a child, ABCD, unless we change that definition. Then what happens once the parents divorce? So it just says where a married couple obtains a divorce after the creation of an embryo, both parties reserve the right to withdraw consent of the implantation of the embryo, which has been created by their sperm or ovum. Agreed. But by virtue of having that word preborn, then it means that you are insisting that this child should not exist. I'm not sure how to put it. So perhaps that preborn word should be looked into, and we see how to go about it. Yeah.
Sorry for interrupting you. We have Justice Patricia Nyundi, who's just joined, and I'm not sure she might be staying with us, so I just wanted to recognize her presence.
Okay.
Judge of the High Court, as you continue your presentation.
Okay. So coming to part of part four on gestational surrogacy, a woman of 25 years, age limit. Erika had indicated that we have issues, some countries don't have age limit. Why we have the age limit in the medical fraternity, Dr. Kireki would explain that more, is because at a certain point in life, a woman is usually considered to have matured internally and psychologically. So when they put 25 years and you must have had a child, we are assuming that by 25 years, if you are not raped, then that is when you have had a child, who is at least most fertility centers will actually want the child to be at least 3 years and above, so that it is in an area where the child is not breastfeeding, or you're not limiting access of the child to the parent. So why we put 25 years as opposed to 18 years is, even though an 18-year-old is an adult, it's a baby adult, to be specific. They've not really gone through life and stuff like that. And if you expect them to have had a live birth who is at least 3 years, if they were not raped, then it figures that by that time, at least they'll be 25 years and above. So giving a lower age is good. Giving a higher age would be recommended, because maternal risk increases when the age of a person increases. If you're a 40-year-old, you are actually at more risk when you're pregnant and all that, than as opposed to maybe a 25 or a 30-year-old. So we can't just say that we let the surrogates, because some surrogates can, as long as the doctor passes you and stuff like that, you can even go on and carry at 50 years. But do we want to really put a person through the risk of pregnancy for the sake of another party. You know, if it is your own child, that's different. This is your child, you're bearing your child. But do you want to bear, because surrogacy is caring for somebody else, do you want to put somebody else through the whole process just for the sake of another party? And you know, the older you get, the more risk you get in maternal carriage. So personally, I think 25 should stay. I personally would also think that there should be a higher age limit, maybe perhaps 45 or maybe 40, where surrogates above 40 years should not be able to gestate. I don't care if they're healthy or wherever, but this is, they're carrying their own child, that's fine. But if you're caring for somebody else, then perhaps we should avoid putting them at risk just for the sake of somebody else. Still on surrogacy, when it comes to the person 28(2)(a), the person has the capacity to enter into the agreement under this. The agreement, the capacity, I still insist, informed consent is very important, and other issues. And they should also undergo psychological analysis. I've not seen here where psychological analysis and counseling has been indicated, but all surrogates should go through psychological analysis. And if you see in all other countries, psychological analysis report is very important before even surrogacy is undertaken. In South Africa, in fact, just the other day, it was even ruled that psychological analysis of the surrogate's children should also be undertaken, because this woman is going to carry a pregnancy. Her children are going to see her pregnant, but at the end of the day, they're not going to see this child. So it kind of, you know, the problem with ART is it's only 44 years. So new things are coming up, new experiences are coming up, and things, and because people never used to talk about them initially, because it was a taboo, kila mtu ananyamaza, that we never used to have a lot of data on how these children grow up. But now that the children that were born through surrogacy and all that, now that they're grown-ups and they're talking about their experiences and all that, some of them complain, we saw mommy going through pregnancy, we didn't even get where we were never prepared for this. We didn't even know if this child died or went through what. So South Africa now has actually introduced that the surrogate has to go psychological analysis and counseling, as well as any existing children of hers, so that before even the surrogacy agreement is registered, there has to be a psychological report both for the surrogate and any existing children of hers, so that at the end, the children are also not traumatized that their mother went through this process and did not come out or ever. So psychological analysis and counseling is something that I would like to be included. I am glad that we have indicated there has to be separate and independent advocates of the High Court for both parties, so that there is equal, because most of the people who go through surrogacy, most of the surrogates who carry, most of the women who become surrogates, actually from low income. So the power play is there. Intended parents are rich, have monies and all that. The surrogates are poor girls. So if you're using just one advocate for both of them, there's the balance of power is not there. So I'm glad that is there. So that is something that I like. Legal process, the transference. As you've heard, a lot of countries, actually, I agree, a lot of countries that have surrogacy, an act on surrogacy or assisted reproductive technology, insist that there's a legal process to transfer rights from the parent, from the surrogate mother, who is the birth mother, to the intended parents. You know, in some situations, you'll actually have three mothers, especially if you've had an egg donor. You'll have the birth mother, who is the surrogate, you'll have the genetic mother, who is the egg donor, and you'll have the legal stroke intended parent, who are now the commissioning parents. So with the legalities of transferring, it becomes a little bit easier on that. However, from experience, it is tedious, time consuming, and all that. I would prefer the South African way of registering the agreement way before transference, way before the treatment starts on a gestational surrogate. An agreement is indicated, parties are identified, and then the agreement is registered in court the way South Africa does, as opposed to the way UK does, where they do it after the baby has been born. I think before the child has been born would be ideal, because now there you can eliminate other issues. Because when you're transferring parental rights at the end, what if some of the issues were not taken care of? Not all doctors are ethical. We insist that there has to be a genetic link. What if one of the doctors just did embryo transfer in a surrogate where there's no genetic link to any of the intended parents? Now, in the best interest of the child, what happens? You see that it will just be a cogma and all that. But if the registration of the agreement is done before treatment commences, then you can eliminate some of these things so that by the time the child is being born, the parents are not worried about the whole hula boo of legal rights and all that. However, there has to be a legal process. It is important just so that we do not go down the road of trafficking children and it does not become a slippery slope where if today I can be given a child, what makes it difficult the following day for somebody to register this child in another person's name? So a legal process is important. This bill does not provide for a legal process. It just provides for quick work. However, let me specify this. UK is trying to amend their gestational laws. They had their surrogacy law, I think, in 1985. It actually came into force before the Assisted Reproductive Technology Act. The problem that I was actually part of the sessions that were ongoing about the amendment of the laws, one of the things that they actually acknowledged is it was a knee-jerk reaction, the way we are having some knee-jerk reactions by bringing about laws. It was a knee-jerk reaction, and some of the things that they had put in the act or in the bill then are not sustainable or something, they do not go with the current situations. And that is why one of their main proposals in the report that has come up and in their current bill that is on surrogacy is there's no, as in the parties are acknowledged as parents from the word go. There should be no parental order. They do away with the legal process so that if the clinic can acknowledge that these are indeed the parents of the child, then the intended parents are acknowledged as children from the word go. This is also what is being practiced in South Africa in some way, because you register the agreement in advance so that by the time the children are being born, they're already acknowledged as the children of the intended parents. India, as of yesterday was Thursday, Wednesday, they had a discussion where they want to do genetic testing way before this testing is done, so that by the time the children are born, they are acknowledged as the children of the intended parents. Why are people going this way? Because it is so stigmatizing. You have no idea to go through assisted reproductive technology. Umeambiwa wewe ni tasa, wewe huwezi zaa, sperm yako haifanyi kazi, and then you give birth, and then you also have to go through courts just to acknowledge that these children are yours. So even if we come up with a legal process, which I advise, we have to make it very easy, accessible. And even, it figures a point where even the parties themselves can just present themselves to court and do the process without necessarily having to go even through advocate. I understand that it is our bread and butter, but at the expense of these people, really, let's make it in a way that it is easy. Hata wakipewa wenyewe wajipresent kotini the way the Children's Act, they can present themselves in court, and then they can be able to present themselves and all that. And as someone has insisted, it also builds on confidentiality. Some of these parties, once they've gone through this treatment, then they have to go to another lawyer, then they have to go to wherever. It's hard. And that is why there's a lot of cases. If Dr. Kireki was here, he would even acknowledge this. There's a lot of cases, backdoor cases, where people are now exchanging IDs. If I'm talking, if I'm giving birth on behalf of Esther, for instance, Esther gives me her ID, I go to give birth, they register my name, we go to wherever, because nobody is going to follow it up, and because the court processes are very tedious and confusing. So that is something that I would think we can also look into it. Life insurance for the surrogate should be provided when she starts her treatment process, because as you know, pregnancy, even in its normal capacity, people who are just gave birth, who are normally getting pregnant by sleeping with each other or something like that, can die in the process. So what if you're going to die and leave your children here and every other thing? So that is something that should be taken into consideration. 31, a person shall not do any act at any stage of an assisted reproductive process to determine the sex of the child to be born through the process of assisted reproductive technology. I agree. However, I would like the word intentionally, shall not intentionally do any stay. Why am I saying this? Because PGS, PGD will give you the sex. As in, when we are doing this PGS, pre-implantation genetic screening and genetic diagnosis to know if there's issues with your embryo or something, one of the things that it tells you, because most of these genetically diseases are sex-linked. They either follow the Y chromosome or the X chromosome. So at the end of the day, it will tell you embryo number 1 is a female embryo and it has ABCD disease. Embryo number 2 is whatever. So it will definitely tell you. So if you're going to prohibit sex selection, we will still know what sex it is. However, let us not just limit the need to not doing it intentionally. If you're doing it for diagnostic purposes and stuff like that, fine. But intentionally just going to get a child, my senior Enrica had indicated that she would like, if you're going to use a lot of money to go through IVF treatment, then you should be allowed to get whatever sex of a child you want. My proposal isn't that. I understand where she's coming. She's usually very controversial on this, and I'm very happy that she does. But my worry isn't that infanticide? Aren't we just practicing infanticide in another way? Aren't we just doing designer baby creation in another way? Aren't we just playing God? Isn't it a slippery slope? Where do we stop? Next time, Ruby will insist, I want a child with blue eyes, which, because of genomic sequencing, it is something that is possible. You just remove one of the chromosomes that deals with the eyes and replace it with a chromosome that you want a blue baby eyed. So isn't it a slippery slope? Today we will say, fine, I only want girls. And then tomorrow, I want girls with blue eyes. Then kesho kutwa, I want boys who are 6'4", who can play basketball, who have an IQ of ABCD. So we will start small, yes, but it will be a very slippery slope. So personally, I think sex selection should just be specifically to identify a disease that is chromosomally linked, and it should not be done intentionally. So access to information, part 5, I still insist, we are Africans. This information should be limited. I don't know how we are going to keep it, especially the keeping or use of gametes of persons or an embryo taken from any particular woman, or the information that is going to be kept in this database and all that. I don't want it to be seen out there that I used a sperm donor. Let it be my prerogative to tell my child that, Daddy, I was not able to get a husband or a man or whatever, and I decided to go to a sperm bank and use, not that it is in an informational booklet somewhere where people will keep changing the ninis, and the following day, Edgar Barre will find it and, put it on some blog and stuff like that. I personally think we are not there yet. We are not there yet. Perhaps we can do how many children have been born without necessarily disclosing this personal information, how many children have been born out of assisted reproductive technology or surrogacy or something like that, but how many donors have contributed, how many, all that. But about specific information that Ruby used a sperm donor or Esther and wherever used a surrogate, I think we are being tunaenda mbali sana. We are not there yet, in my opinion. So when it comes to the information access and database, yes, we may have it, but may we limit it just to specifics so that we have information that can give us and guide us on coming up with laws and other procedures to do assisted reproductive technology without infringing on the rights, confidentiality, and privacy of these clients, who I have told you over and over usually go through stigma when going through this treatment. Even if information, someone has said that information, medical information is usually privileged. No, it is not. I'm afraid it is not. It is privileged by word of mouth, yes, in writing, but you will be so surprised at how much information our medical practitioners give out on people out there that is supposed to be privileged. So we should just not be in a hurry to give out information that will identify other parties, especially if these parties are not necessarily freely giving out their information, because some people don't even tell people that they are going through assisted reproductive technology. Mtu anakuambia tu anaenda church, anaanza kupeana testimony, I prayed, nilikabarikiwa, hajasema alitumia sperm donor or egg donor or something like that. So it is not. So 42(5)(b), a woman shall not be provided with any treatment service that involve B, the use of any embryo taken from another woman if the consent of the woman from whom it was taken has not been obtained. I want to tell us that there's something called embryo donation. Embryo donation. Embryo donation is where a woman donates an embryo that has been created. It already has sperm and eggs and has been created. So if it is known, because there's anonymous donation, the way sperm donation can be anonymous or known. So if it is known, then it is easy to obtain permission. Say, for instance, my cousin has created embryos she has done her own treatment and she no longer wishes to do extra treatment, then she donates embryos to me. If it is known, it is fine. But if it is anonymous, it will be very hard to get consent from this person because who is donating. So I would like this act or this bill to have a whole paragraph on just embryo donation. Who qualifies to get embryo donation? Because you do realize that embryo donation, this is a child who is not genetically related to this couple. The child does not, because you're getting an embryo that has already been created. So you're not genetically related to this child. You're not so, or you're getting sperm and egg donor. You know, it is just like getting a sperm donor and an egg donor. So I would like the bill to have a whole section on embryo donation. Who is qualified to get embryo donation? How should it go about? What are the parental rights and responsibilities of the children born out of this, embryo donation? And if, because somebody anaweza fika huko mbele aseme, mi hata huyu hana genetic link yangu, hana genetic ya bwana yangu, and it's not like you did an adoption or what, you actually carried the child and born it. So there should be a whole paragraph on embryo donation. That is something that we are not seeing here. It is something that is happening, and there should be a whole paragraph. Let me just take you back to the sex selection bit. There should also be a whole sentence or a 1 or 2 sentence. Or now we are not just talking about PGS. Technology has advanced. We also have a sperm sorter, which sorts out sperm way before fertilization occurs. So they should also, the way we have limited on the use of PGS, we should also have a limit on the sperm sorter, because when are we allowed to just sort the sperm and get a Y chromosome or an X chromosome, whatever, and use it? So that is something that I would like the bill to capture. Then 43(2), the storage period in respect of embryos shall be a period not exceeding 10 days, or as the license may specify. I agree with that. However, you tell us to keep the embryos for 10 years, and then how do we dispose of them? You've not given us how to dispose of the embryos. As we have indicated, and rightfully so in the bill, that an embryo is a pre-born person. So we cannot just unleash it to the world na tuache ikufe. That's like killing a human. As in, are you going to charge me for killing? And who is supposed to do the disposition? As an embryologist, there's no way I'm putting an embryo out there to die. There's no way I'm putting chemicals in the embryo to die. There's no way I'm killing an embryo, because this is already a preborn person. So tell us how we are going to store the embryos for 10 years, yes. But how are we going to dispose of them after the 10 years? And then, apart from the embryos alone, how long should we store sperms? How long should we store eggs? Because all these gametes and the embryos can actually be stored even for 100 years. They are okay. However, disposing of them should also be something that the Act clearly tells us. And then, still on the disposition, it shall be the responsibility, 45(1), shall be the responsibility of the person under whose supervision the activities authorized by a license are carried, blah, blah, blah. C, that proper keeping of gametes and embryos, and for the disposal of gametes or embryos that have been allowed to perish. How are we going to allow them to perish? How are we going to dispose of them? Just don't say dispose. How? Give us particulars of how we are going to dispose. At the moment, what most fertility centers do as a way of disposing of the embryos is donating to a couple. As I've told you, there's embryo donation, but that is the only way that we have a legal way, because we cannot, the bill specifically says that you cannot use these embryos for research. So we cannot donate them, say, to Nairobi University Medical School for research. It cannot be used for other purposes, so we cannot donate them to other whatever, so you can only donate to another party. However, it's not kila mtu anataka hiyo, watu wanakuja ku create theirs. So you actually have excess instead of having fewer. So that is something that I need to be, it needs to be very clear. Yes, we can keep them for 10 years. Yes, we will keep them for 10 years. But after the 10 years, how are we going to dispose of them? Can we have a whole paragraph just on disposition of embryos, gametes, sperms and wherever, so that we have a whole paragraph in the bill or the upcoming act to dispose of it. 52, these are supposed under Part 9. This is Part 9, yes. Provisions on delegated powers. These are supposed to come under, apparently regulations are supposed to be made on the following. However, I would like to see some of this in the main act, in the main bill, not in the regulations, just in the main, even if it is a mention, a paragraph or what, and then the regulations can take care of the rest. One, donor. Donors. We have donors. We have gamete donors, that is sperm donors and egg donors. We'd like to know how many times can a donor be allowed to donate their gametes, so that we don't have issues where a donor, say Harriet, donates, and then a lot of people within her circle get children from the same wherever, and they're going to the same schools, they're going to wherever, and they start having sex and they start carrying each other, going to the same javas, and there's inbreeding going on. So how many times can a donor donate? What should be the compensation? Because we have discrepancy on compensation. Why do we have discrepancy? Because donation, as the word says, it is donation. It is voluntary. You do not expect to be paid for the donation. So we need to have maybe how much minimum or perhaps maximum a donor should get, how the eligibility, what kind of donors should we have? Should we have 18-year-olds as donors, or should we just restrict ourselves to 22-year-old to around 25 years? And then how many times? And then storage, as I have said, tell us the amount of time. Yes, you've told us 10 years, but can you also give us ways of how to dispose of the rest? And then most importantly, this one, I don't even want it to be in the regulations at all. I want it to be in the main act, number of embryos that can be planted in a woman. You do realize that because we do not have an act, because we do not have regulations, we have issues with the number of embryos that are implanted in a woman. Usually in countries that have regulations, it has been specified that only one embryo should be implanted. But the problem is fertility treatment is very expensive. Ukieka moja leo, ufanye upate haiko successful, ukuje kesho tena uweke, that is another 500,000, unless you had frozen embryos where now you'll spend about 100 to 200,000. Isishike uweke tena, because embryos, it's a matter of piki ponki. Even if you do PGS or PGD, it just tells you the size. The size does not equal to the quality. Unless you do PGS, which will cost you an extra 200, 300,000. You see, the more you go to more technologies, the more monies you have to pay. So we need to find out how many embryos should be implanted, because you find people implanting even 3. Someone gets triplets. Multiple pregnancy essentially is a risk pregnancy. So that is not something that you would want somebody to go through. So that is something that should be in the main bill, not even in the regulations. We need to know how many embryos should be implanted in somebody. Just now that I'm nearing my end of wherever, I would like to speak on something. Let me just, it won't be shared because I can't share it here. But I just want us to remember some things, some of the things that we should remember when we are doing, when we are coming up with the rules and regulations. For instance, the status of embryo, that is, I've said, life, when does it begin? Number of embryos to be transferred, third-party reproduction, meaning gamete donation, donor anonymity, surrogacy. What are their rights? What is commercialization? Where does it end? Do we want to be able to talk about donors? Do we want to have a database that has donors, or do we want to be anonymous? Do we want to keep anonymity and stuff like that? So those are some of the things that I think the Act should come into play. And then in respect, make mandatory in Part Act. Yes, those are some of the things that I have seen in the bill that I would like corrected. And of course, we should, I wish I had shared some of my notes. There's some legal and ethical issues that would actually help us in formulating or coming up with some of the provisions in the bill and stuff like that. That's it. Thank you. Abega Amanda, or what's his name? Elvis.
Hello, I'm here on his behalf. This is Wendy.
Okay.
Yes. Thank you so much for the presentation. We've had insightful discussions from all the speakers. And I would just like to ask the participants if they have any questions. Please raise your hand, and if it's relating to a particular speaker, then you can also mention the same. So let me see from the members list who has raised up their hands. So I can see Ayo Osen Odiko. I hope I made that correctly. Then we can have Wanyoike Peter next. Ayo, please unmute.
Thank you very much. This one is for Ruby, and I think I texted it before in the SMS messages. With regard to Article 20, if you can go back to it, speaking about using the sperms of a man after he's dead. Would it the same case not apply to a woman? And if we have a law that takes care of the sperms of a dead man, and we do not have a law that takes care of the ova of an intending mother after she's dead, wouldn't the law not be creating an equal provisions for the intending parents with regard to protecting the particular individual that might have transitioned on through death? Over to you.
Can I answer that? I acknowledge that yes, it is a little bit discriminatory, but the issue, the mischief I think this is playing is, you can get sperm from a man who is already dead, but you cannot get eggs from a woman who is already dead, because for you to get eggs, you have to go through the process. There's a process, induction process, where you're given injections for a specific number of days, and then they have to retrieve the eggs and stuff like that. So I think this was because a man, after you can get sperm even after the man has died, one, or two, the man may have stored sperms and then they use. But if it is in a position where, if it is in a case where the woman stored eggs before she died, then you see it also becomes a little bit more complicated, because now it will also involve surrogacy, because now the woman is dead, so she cannot carry a child that has been created from her own embryos, from her own eggs, so she's dead. So there it cannot even proceed, because the surrogacy laws will prohibit that bit, because genetic link, you cannot use embryos or whatever that has been created from someone who has died. But I agree that they should not be discriminatory. However, it becomes a very tad complicated to get eggs from a woman who's already dead, but very easy to get from a man who is dead.
Right, but if you look at 20 clearly, A presumes that the mother is alive and she's proceeding with the sperms of the dead father, right?
Yes.
Right. So why do we not add a provisions for a mother who has died? Her ova is out there circulating with a potential father who is alive. Over to you.
The mother was married to the man at the time of death. So
can I respond to that?
Yeah.
Actually, when I saw the comments that were on the comment section, and one of the things, what I indicated is I'm actually going to relook at it to see whether there's element of discrimination, because there's something for it. There's something to it, and I think we'll look at it to see how we can put it better.
Thank you, Honorable Millie.
Thanks.
But just to point out something, I wish Kireki was here to explain this. You see, when it says the mother was married to the man at the time of the death, we are assuming that it is a sperm that has already been either retrieved or can be retrieved when someone has died. An egg, you cannot retrieve an egg unless it is a frozen egg out there And you know, the issue with the frozen egg is once it has been fertilized, because the woman is dead, the man cannot be going around, because the woman is dead, the man cannot be going around using it unless he's going to use another third party, which now goes into the elements of Enrica for surrogacy. And before you do the surrogacy process, there are elements that you have to meet first before you undergo the surrogacy process. So I think that was left out there, though I agree with you that yes, it is discriminatory. It might have been left there because it oversaw the part that where there will be another legal process that you'll be required to undergo before you can use an egg to go through the treatment process.
Ruby, Dr. Gesore is here, Edna Kemunto.
Mm-hmm.
I know she's a gyna. If she's available, unless she's attending to a patient, she can also assist. Huh?
Yeah.
Edna, are you able to? Dr. Gesore?
I think she's a little bit not here.
Okay, okay.
But anyway, we can look at it and see that, yeah, maybe you can do that, but legally, medically, it won't make much difference. Perhaps legally it will make difference, but medically it will not make much difference. That I can tell you. But Honorable Millie has said she'll look into it and will really do the whatever. But medically, it will not make much difference. Legally, it shall.
Thank you so much. I hope that suffices. The next question is from Wanyaike Peter. Please unmute.
Thank you very much. I am a medical doctor myself, and I have two comments. You can hear me?
Yes, Doc.
Yes, we can.
Yeah. One is that Article 20 and Article 45 and the best interest of the child. Is there a conflict between those three? That is one. Two is that
can you please just expound, because I'm also hoping to bring amendments based on what people give here.
Yes. Now, when you talk of the best interests of the child, the surrogacy laws, I think in my view, we came up with the surrogacy laws. They have been overtaken by the best interest of the child. Because if you look at the best interest of the child, then whether 20B that talks of the about the embryos, whether you multiply, we put multiple. When you talk of 45, when you put a single embryo, or whether you put multiple, or if there is genetic relationship, and then you look at the current Children's Act, and you look at the best interest of the child. Once that child is born, really, the surrogacy laws. Who is the surrogate? The surrogacy laws, I think, they are relegated to the back. So I think there is a conflict there between the current Children's Act on the best interest of the child and those previous 20B and 45B. I must say I haven't read them very well. I've just listened to the speaker now when she was going through. I have not interrogated them very well, but from my position, I think there is a conflict.
Thank you.
Two, and this is addressed to the speaker. I just want to, I think the medical doctors, and especially the ones that deal with the ones dealing with infertility, they have and most medical doctors, they have a high level of confidentiality, unless you want to go out of business, because that is business. And for all doctors, unless you want to go out of your work, most people, there is a very high level of confidentiality about patient records. But yes, the speaker talked about people who go to church and talk about all these things. But those are not doctors. So I would probably like to collect the view here about the non-confidentiality issue. Thank you.
Dr. Wanyarike, two things. One, when I spoke about the confidentiality issue, it's not necessarily for doctors, though I can tell you for a fact that some doctors do not have they have confidentiality, but not all. And you do realize that doctors don't work in a vacuum. They work with other parties. They work, for example, with nurses and other extra stuff. And this database, the doctors may have the confidentiality report privately and all that, but the database is not kept by the doctors. It is a database that is kept by totally somebody different, who perhaps may be an information technology specialist or something like that, and accessing it and stuff like that may be it becomes a little bit hard to ensure that confidentiality is there. Because as medical practitioners, you do realize that you have ethics and whatever that you follow. And even lawyers have their ethics and whatever they follow, but not all professionals have ethical guidelines and stuff like that. So yes, the doctors may be confidential about it, the lawyers may be confidential about it, but what about the other support staff? Because you'll find an IT person, you'll find a receptionist, you'll find somebody else, and then it becomes a little bit. This is not at the clinic level. This is at the database level.
Thank you about that.
Yeah.
Thank you, Dr. Edna. Sorry, Mheshimiwa, you can go on.
No. I was actually asking where you are.
Oh, okay. Dr. Edna Gesore, please unmute. You have the controls of mute and unmute. Just try and see. Because I know the doctor wants to give input, but is having technical challenges.
Wendy, are you able to unmute her? Edna said in the chat that she's unable to unmute herself. As the host, are you able to unmute her?
Just a moment.
Edna, just go down there and then you see the red thingy on a microphone and click on it.
I cannot unmute. I don't know what's up with, maybe it's the device. She's possible to rejoin.
She's trying. She's sent a message.
Okay.
Edna, you keep trying. Let's proceed. Edna, you will prompt us when you are able to unmute yourself at the bottom of your screen.
Can I make some comments?
All right.
Yes, please.
Hello?
Yes, please.
Okay, thank you. First of all, let me just say that I'm very grateful for the feedback that I've received from the participants. They are going to strengthen the bill. Of course, I agree with quite a number of some of the issues, though some of them are still very controversial, but I know we will be having further discussions. I just want to comment very, very briefly, because I know today is a Friday and people have a lot of plans, so that they don't get into the issue of ART in future. So I don't want to take too much of our time. So I just want to indicate that one of the issues that has come out very significantly is on the issue of how do we make the ART process easy on IPs without denying the advocates their bread and butter issues. And I think that is something that we can discuss. I know Enrica has spoken very strongly and given comparative analysis. And Ruby has also indicated from the perspective of especially the IPs. And I want to just indicate that when Honorable Joyce Lay was contributing to this bill, she broke down and cried before the floor of the House when she was giving a narration of the process of trying to adopt our own biological child that she had gotten through surrogacy. And one of the things that we wanted to do then is to make sure that we find a process that is as simple as possible for the IPs. But I think it's something that we can discuss with the practitioners so that we can find a middle ground. The other thing, again, in relation to that, I think maybe going through DNA testing and all that might be very onerous. But again, we can look at it, because I am also, fortunately, the one who also came up with the Act on Counter Trafficking in Persons Act. And so if, for instance, we need to strengthen some aspect of the Counter Trafficking in Persons Act so that people don't abuse it, that is something that we can consider. But so that we don't also make it so onerous, because part of the reasons that most of the women approached me was just that the legal processes they have to go through in order to make their children their own children. They thought it was not only difficult, but discriminatory. Then the other issue that has also come out is whether we need to look at a surrogate register, an IP register, a register born out of children born out of the process. I think that is a discussion that we will have as against the issue of confidentiality, and as against, for instance, the right of the children to know, especially should they have medical challenges in future. So that is some of the things that we need to know. Maybe somebody may want to know if maybe I'm biologically related to somebody I want to get married to, or maybe I am related to somebody, or maybe sometimes, as we know, maybe there are people who can help me who are related to me biologically. And if you don't have that information, it might create a problem for children. So it's an issue of balancing the rights of the children as against confidentiality and privacy rights. So I think that's one of the things that we need to continue discussing to see how we go about it. The other issue that they already asked was whether on the issue of the bill limiting the right to couples, only limiting it to couples with medical conditions. And I just want to say, as a mover of the bill, I have no problem expanding to couples who don't have medical problems. I want to also indicate that, the bill went through amendments, some of which were not supported by me, but which passed. So some of them may be actually against my own wish, because it has come in this form, because it was passed in the National Assembly in the last parliament in that form. Again, on the issue of choosing the gender of a child, I personally have no problem with that. But again, Ruby has also raised certain very critical issues that we need to look at, and which we may need to look at how we can balance, how people may look at designer babies vis-a-vis the fact that maybe parents need to determine what sex of a child they may want. And I think with the technology and growing, with the developments, maybe it's something we need to think about, and whether by law, then we exclude the other categories where people may want to do designer babies. Enrica asked a question whether one of the reasons that the bill could have been in Parliament for long could be because we have not separated the legal issues from the clinical issues. And I want to assure you that no, that has not been the case. This bill has actually, in the 2 times that it has come to Parliament, has received tremendous support from the National Assembly. The first time, I think it almost got 100% or 98% support. The second time, there was a bit of phobia over the issue of LGBTI, that people thought that there are aspects that may promote LGBTQI. But the issue why it has faltered is because of the supremacy battles between the Senate and the National Assembly. It passes in the National Assembly and then fails in the Senate. So we are trying to look at how I've actually raised it with the Speaker of the Senate. I want to actually indicate that we have the Family Reproductive Healthcare Bill, which is bigger and more comprehensive in relation to reproductive healthcare. We chose to separate this aspect from the reproductive healthcare bill, which is seen, especially by our religious sector, as more controversial. Then I think the other issue I've already responded to the issue that Ayo raised. The issue of same-sex couple does not occur here. And I think maybe for the rest, I would just want to say that you have raised very, very significant issues that I have picked up. I may not mention them all. Ayeta, who I prefer to refer to as Ruby, I've always called her Ruby, has raised many, many significant issues on definitions, which we will look at and add to make it better. And even the definition of the bill itself that may change to medically assisted reproduction. Richard Kiketo has asked about whether is there a right to a child. I don't think there's a right to a child because that would be playing God. I don't have a child now and I can't say I have a right to a child. But you may have a right, you have reproductive rights, but you don't have a right to a child, because that means we are presuming the state can play God. Of course, then there are issues of anonymous donation and issues of speculative purposes. I want to thank Commissioner Luanga on the issues that you've indicated, and I'll pick them up. Let me not talk about everything. Of course, Harriet Kosgei has also raised significant issues that we look at. I can't mention all of them, but I've written them all down for purposes of seeing where we can amend and make better. Otherwise, I really do appreciate all the feedback that you have given. And I hope that they shall pass in the amendment process. But I would also want to encourage, if you feel very strongly about a position, please send the memorandum to the Parliament through the address that was given. Thank you and have a blessed weekend.
Thank you. Thank you so much for your presentation, the engagement we've had with members and the doctors on the call. Thank you so much. I would suggest, because of the interest of time, let's see if Dr. Edna Gisore can unmute herself. And if not, then we can direct any further questions to the email address I will put below. And I can see our chair is on call. We can have closing remarks and let you continue with your Friday activities. Dr. Edna, are you able to speak? I made you a co-host. Okay. She says she's in surgery. Thank you so much, Dr. Edna. We hope we can engage next time. Chair, would you want to maybe give closing remarks? I'm just posting the email address where you can share your feedback and we can collect this into a memorandum.
Thank you, Wendy. Thank you so much to all the people who are presented today. Thank you so much to Honorable Millie Odhiambo. I know I called her very late this week, and I'm so grateful that she could make time to engage with us this afternoon, despite the fact that you're very sleepy and jet lagged. And I want to say thank you very much to Ayeta, who I did not know is called Ruby. Now I know. Thank you. Thank you so much to Enrica Dulo and every single person who has contributed today. We really appreciate your contribution, your interaction. We have been noting down all your comments, and we'll be sure to include them in the memorandum that we'll be forwarding to Parliament. And so on behalf of the branch, and it is asante sana for your sharing your thoughts, for sharing your experiences, and for this opportunity to be able to allow us to pick your brains so that we can be able to make this particular piece of legislation better for our society and for our practice. With that, I wish you a wonderful weekend. Keep warm, keep dry, and see you next week. Asanteni.
Thank you. Enjoy your weekend, guys.
Thank you too.
Thank you. Thank you.
And thank you to Justice Patricia, my classmate.
Thank you. Nice weekend, everyone.